Hi all, in this video I will be sharing an overview of some topics in the fourth module of the subject Professional Ethics based on the 2019 scheme KTU syllabus. The contents included in this video are collegiality and loyalty, managing conflict, respect for authority, collective bargaining, confidentiality and occupational crime. First topic is collegiality. So, before discussing about collegiality, we should know the term colleague. Colleagues are those who united in a common purpose and respecting each other's abilities to work towards that purpose, and it consists of various aspects that are respect, commitment and connectedness. Collegiality is essential for a teamwork to be effective. The term respect here means one gets back the support and cooperation in return, and it will be mutually beneficial for both the parties. And commitment is towards the moral decisions, actions and goals of the organization and values of the profession. Connectedness means the shared commitment and mutual understanding. It ensures the absence of egoism and paves way for progress of both the parties. And the colleagues are to be respected for their work and the contribution towards the organization goals. They should be valued for their professional expertise and their dedication to the work. The coordination among all the members enhances the quality of the work in an organization. Next topic is loyalty. Loyalty means the faithful adherence to an organization and the employer, and it consists of two types of loyalties. First one is agency loyalty and the next one is attitudinal loyalty or identification loyalty. Agency loyalty means to fulfill his or her contractual duties to the employer. The duties are specific actions one is assigned. For engineers, the most important obligation will be the safety, health and welfare of the public. Attitude loyalty is concerned with the attitude, emotions and a sense of personal identity. It is a willingness to meet moral duties with attachment and trust with the employer. People who work grudgingly and spitefully are not loyal to the work. This type of loyalty is alright when the organization works for the development of the community, and also working together with falsification of records or serious harm to the public will not merit loyalty. Next topic is managing conflict. As we know, the term conflict refers to any kind of opposition between two or more parties. Whenever people have to work together, they will not always be in perfect agreement on all the issues, goals and their perceptions. If it is managed correctly, it will be helpful in meeting the organization goals. In order to manage conflict, the manager needs to understand why the conflict arises. Usually the causes of conflict are problems in communication. It may be the unfamiliar language between them, or any misunderstanding, or any personal relationship, or the personality characteristics. There are various methods for managing conflict, usually three types: collective bargaining, conciliation and mediation, and finally arbitration. Collective bargaining is the process of direct negotiation between representatives of employers and their employees for the settlement of disputes. In this, the mutual rights and obligation of both parties that are agreed by them through negotiation are then written down in the form of an agreement or contract which is legally binding on them. When collective bargaining fails, then we adopt conciliation and mediation. Conciliation consists of a series of conferences including informal sitting between representatives of two parties. It is usually designed to create a friendly atmosphere between them. And mediation is when the conferences are held with an outsider as chairman, and this process is known as mediation. The presence of third party acts as a moderator. What they themselves cannot settle may be solved under the influence and suggestions of an outsider. And arbitration is adopted when the above two method fails. In this, a third person is chosen as an arbitrator by agreement between the employers and employees. The arbitrator gives hearing to both parties and then he offers his own solution to this dispute. The conflict management process is as follows. First one, preliminary step. Next step, diagnosing the issue, and finally applying any of the conflict handling modes. In preliminary step, it is the first stage to know the full details of the conflict. If it is in the initial stage, it requires less effort and much efforts needed at an advanced stage of conflict. And diagnosing the issue. The second step is diagnosing the issue. The issues involved in the conflict should be analyzed and should understand what this conflict is all about. That means the nature of the conflict should be found out in the second step. Third one is conflict handling modes. The important strategies are as follows. First one, to avoid appearance of conflict. The approach suggests that such conditions and atmosphere should be created in the organization so that there may not be any conflict. Second one is not permitting conflict to surface. This strategy suggests that loyalty and cooperation to the group is supreme. People who are not loyal and cooperative should be removed or punished. The next one, mediation, as said earlier. Next one is letting the parties in conflict to settle their score. They are allowed to fight out the issue by themselves. And final one, mutual problem solving. When two parties are conscious about the existence of a problem, they will try to solve their dispute themselves. Next topic is confidentiality. The term confidentiality means keeping the information on the employer and clients as secret. It is one of the important responsibility of an employee or an engineer to maintain the confidentiality of the organization or the employer. When the word confidential is added to any information, it means that it should not be shared with one and all. Maintenance of secrecy refers to the unrevealing of any data concerning the company's business or technical process that are not already in public knowledge. Confidentiality can be justified by various ethical theories. According to right-based theory, rights of the stakeholders, right to intellectual property of the company, etc. are protected by this practice. And based on duty theory, employees and employers have duty to keep up mutual trust. The utilitarian theory holds good only when the confidentiality produces most good to most people. And finally, the act utilitarian theory focuses on each situation when the employer decides on some matters as confidential. Other than the ethical theory, the following moral principles also justify the concept of confidentiality, that is, respect for autonomy, respect for promises, trustworthiness, and respect for public. Respect for autonomy means respecting the freedom of individuals and organizations to identify their legitimate control over the personal information of themselves. And respect for promises is giving respect for the promises made between the employers and employees. The employee should not disclose the promises given to the employer. This information may be considered as sensitive by the employer. Trustworthiness means maintaining confidentiality by lawyers, accountants, etc., which are necessary to develop confidence and welfare of the individuals and organization. And the last one is most important for the benefit of public welfare. Then comes the types of confidential information. On the basis of acquisition, there are two types of confidential information. First one is privileged information and second one is proprietary information. Privileged information is the information that is available or accessed by virtue of a privilege. An engineer working on defense project may know that the missile he has developed is to be tested against a terrorist across the border. The information he had got only because of the privilege or the job he has got. Next one, proprietary information. It is the information owned by the organization. Some internal communication in an organization is marked as proprietary. Example, trade secret. It is protected legally by the organization from use by others, including the employees. Then, on the basis of severity of risk from breach, confidential information is divided as obvious information and information of lesser confidentiality. Obvious information is the information of the products yet to be released. The risk or loss from the breach is large in this case and may threaten the survival of the company. And information of lesser confidentiality relates the business information such as number of employees working on a project, the marketing strategy of the organization, or the substitution of materials used in the organization, etc. The risk or loss is relatively less as compared to obvious information. Next comes respect for authority. An authority means a person having the administrative power and control. The authority comes into play a great role in effectively and efficiently transferring decisions to actions. In order to meet organization goals, the professionals should possess respect for authority. Usually there are two types of authority. First one is institutional authority and second one is expert authority. Institutional authority is the authority which is exercised within the organization. For example, the project managers have the institutional duty to make sure that the projects are completed successfully. And the expert authority means the ability to administrate others based on his or her knowledge and expertise. For example, they are advisors, experts, or consultants in a specific thing. Next topic is collective bargaining. It is a bargain by the trade union for improving the economic interest of the worker members. The objectives of collective bargaining are to increase mutual confidence between employer and employees, to regulate terms and conditions of employment without intervention of a third party, to protect the interest of the employees, and to raise the socio-economic attributes of the employees. There are four types of collective bargaining: distributive bargaining, integrative bargaining, attitudinal structuring, and intra-organizational bargaining. In distributive bargaining, one party's gain is another party's loss. For example, wages. Next one, integrative bargaining. In this, both parties may gain or both parties may face loss. And attitudinal structuring. Such bargaining involves shaping and reshaping attitudes of a person to positive and in a cooperative manner. And intra-organizational bargaining aims at resolving the internal conflicts within the organization. The process of collective bargaining is as follows, usually in six steps. First one, preparing for negotiations, identifying bargaining issues, negotiation procedure, reaching the agreement, ratifying the agreement, and finally administration of the agreement. Final topic in this video is the occupational crime. Occupational crimes are crimes for the benefit of an organization or a company. These are also known as white-collared crimes. An occupational crime may be committed by wrong actions of a person through one's lawful employment, or crime by an employee to promote one's own or employer's interest, theft or pilferage by the employee, or damage to the property or an employee of one's organization. The various examples of occupational crimes are price fixing. It is an illegal practice in which competing companies agree to restrict prices with a specified range. Next example is industrial espionage. It means simply spying for personal or company benefits. Some common examples of industrial espionage include breaking into company files or trespassing onto property without proper authorization, posing as a worker in order to learn company trade secrets or other confidential information, placing a wiretap on a competitor's phone, etc. Next example of occupational crime is bootlegging. The manufacturing, selling, or transporting products, which is liquor or narcotics, that are prohibited by law is called bootlegging. In engineers' context, it refers to working on projects which are prohibited or not properly authorized. Next example is endangering lives or occupational hazard. Industries who expose their employees to hazards usually escape penalties. Victims have the right to ask, but only to claim some monetary compensation. For example, the asbestos industries in USA were responsible for the death of 1 lakh workers and 27 million workers affected with cancer in the 80s. And another example, even after 22 years since Bhopal gas tragedy, appropriate compensation has not been paid to the victims. Other common examples of occupational crime are embezzlement. It is a type of financial fraud. Then money laundering. It means the illegal process of concealing the origin of money obtained illegally by passing it through a complex sequence of banking transfer or commercial transaction. Next example, racketeering. It means engaging in an illegal scheme. It is a criminal activity in which a person or organization engages in a racket, which means an illegal business. Then altering company records, then committing tax fraud, and misusing company data or property. So that's all about this video. Thank you.